Good morning, Your Honor.
Morning, gentlemen.
Morning, Your Honor.
Are either of you expecting clients?
No, we got a brief update for the court as to why.
Okay, that's fine. I just had somebody identified as iPhone. If it was a client, I was going to bring them in. Shannon, put us on the record, please. This is Pierce versus Allen. Mr. Whiting for the plaintiff, Mr. Hotchkiss for the defendant. Go ahead, Mr. Whiting.
Your Honor, it came to my attention last night via an email at 5:35 p.m. that there have been some additional developments that may have improved the situation. Mr. Hotchkiss and I spoke this morning. We would like the counselor to be able to provide an updated report for the court. I will be contacting the counselor to see if she can provide that. Additionally, there's been some additional text messages that I received in that email last night that I'd like an opportunity to review and discuss with my client in greater detail. Therefore, I would be re-noticing this hearing on after reviewing that and providing any additional updates, documents to Mr. Hotchkiss and the court before we conduct the hearing.
Okay, Mr. Hotchkiss, you concur?
I do, Your Honor. Thank you.
All right, great. Thank you, gentlemen. We'll see you whenever you get it re-noticed.
Okay.
Thank
Thank you,
you,
Your Honor.
Your
Have a great day.
Likewise. I'm assuming Gates, oh yeah, she told me about that. It's still on the docket. Gates is going to be re-noticed. So that leaves us with Harsh versus Hyatt. I see Ms. Curran's present. Okay, Harsh versus Hyatt. Ms. Kerr is here on behalf of the defendant and counter plaintiff. Mr. Harsh, is that you?
Doesn't have his
Your
audio.
Your microphone might be off, sir. I can't hear you. Check your audio settings. Well, you've muted your phone twice. You need to find a different control. We still can't hear you. Check your audio settings. I'm not sure where they show up on the iPhone, but I think you might have your volume turned down. So while we're waiting, Ms. Kerr, is the defendant counter plaintiff present with you?
She's not present with me, actually. She had texted me and said that she was logging on, so I'm not certain where she is. I just texted her back to say, where are you? So.
Oh, she just logged in.
Okay, great.
Ms. Hyatt, can you hear me?
There, it looks like her video's coming on.
Yeah, it's slowly coming on. I still can't hear Mr. Harsh. I may try calling him. That's worked in the past.
Christy, can you
Yeah,
hear
I'll-
us?
I may end up having to call both of them by phone. Well, we just lost Mr. Harsh. I'm going to try to get him by phone.
Okay.
Hello.
Good morning. Is this Mr. Harsh?
Yes, it is, Judge LaFlamme. I'm here with Christy on her laptop here, so we're both together.
Okay.
So it's gonna sound loud. So we're both here, and I saw you I saw Miss Kerr and everything. I don't know if we're getting audio through here, or so I'm not sure, but
Okay.
that's the deal.
We can hear you, and that's good enough for me.
Okay.
Okay, we are here on the counter plaintiff's motion for entry of a default judgment.
Okay.
Ms. Kerr?
I'll get back away from it. That's why I think that noise.
Okay, I'm back away.
Over there.
Why don't you do, Ms. Hyatt, turn off the Zoom connection? I think that might be creating some backfeed. We're not getting anything through it anyway, so it doesn't serve any purpose. All right.
Okay, thank you, Your Honor.
Okay,
Okay, thank you, Your Honor.
Okay, hold on. I'm gonna turn my phone on speaker. Hello?
Yes, can you both hear me?
Yes, we can both hear you.
All right, go ahead, Ms. Kerr.
We're here on the defendant counter plaintiff's motion to enter the default judgment of divorce as proposed. This was issued after the court granted her leave to file a counterclaim when the plaintiff did not appear for the trial back in November. And so he's been served more than 14 days prior to this hearing, and I have her proofs ready and we can put them on the record if you are willing to grant this default motion of divorce.
Well, before we do that, let me ask Mr. Harsh. Mr. Harsh, have you had a chance to review the proposed default judgment of divorce?
I haven't seen any default judgment of divorce, nor has Christy. She sent it to me, I guess, but I haven't saw anything like that. And so I'm not sure. Go ahead.
Let me tell you what's in it, and let's see whether or not this is going to be disputed.
And how did he know about the hearing if he didn't receive the information? I'm questioning, yeah. Okay.
I understood his answer to be, he probably got it, but he hasn't read it yet. Is that accurate,
Correct.
Mr. Harsh? All right, so let me tell you what it says. It says that you'll be divorced, that your marriage is dissolved. It awards legal custody to mom, physical custody to mom, awards you parenting time every Saturday from 10 a.m. until 6 p.m. and the conditions of parenting time are set forth in an order that this court entered back in January, just last month. And it provides that you can have additional parenting time as the two of you can agree.
Okay, well, I'm just going to lay it all out to y'all here right now. I've been able to see my son for the last 2 weeks. I'm at Miss Hyatt's house now. I've been taking him to school, picking him up, doing all kinds of things like a normal family here. Mr. Chris White is no longer around. And so that's the deal. But the problem here is that if there's any other problems like they have arose before and I don't get to see my son for months at a time, and just Miss Kerr, I'd just like to say to you that, this isn't a criminal thing. A child's life here is the deal. And, you want to come up with reasons and things for me not to be able to see my son. I go and pick up my son without a driver's license, and okay, the point of it is that I haven't been down there to pick up my son for the last 3 times on a Sunday, and neither has she. So
Well,
all
that's
these
good.
excuses and these things. Okay,
That's
so
good
I
because
can't
the
see my
parenting time date is on Saturday, so I would hope you're not going on Sunday.
Yeah. Okay, Saturday, but what? No, hold on. I'm not arguing. No, I'm not trying to argue. Okay, we're going to get it settled. But what I'm trying to say is, Miss Kerr, is that I read your text and I see on there when you say, oh, Mr. Hirsch is there and he's violating the PPO and this and that. So I understand that. Okay, I get that. No, I'm not going to argue. So let's go ahead and make some progress here today. And I just want to say that the way that the court system is and how long it takes, if she gets angry at me and I can't see my son again and we have problems. Okay, so I'm just telling everybody here that I'm not going to. No, I'm not going to let this go on anymore.
All right,
so
hold on, hold on. So Mr. Harsh, what this proposed judgment does, it gives you the absolute right to see your child every Saturday from 10 to 6, plus any other time that you wish that the two of you can agree on. This gives you the right. If Ms. Hyatt were to deny you the Saturday parenting time and keep you from seeing your son for an extended period, or even for a short period, you have the absolute right to file a parenting time complaint with the front of the court, or file a motion with the court for an order to show cause why she shouldn't be held in contempt for denying you that parenting time. This gives you the specific parenting time.
Yes,
I realize that sometimes the mechanism for being heard on those kind of complaints doesn't always work as smoothly as you'd like, but frankly, those are the only mechanisms that exist. I can't put anything more in this judgment of divorce that deals with that. I can only deal with it when there's a disobedience of the judgment.
Okay, now everything that you told me, I totally understand this. Now, from day one, I've told Mick Fallahy, which I've blown $1,500 on, $3,500 from Miss Kerr, whatever, into what? To go right back to the same thing that was going on before. Everybody's profiting from everybody's misery. That's what this is all about. But anyways, what I'm saying is this is the original order that Christy and I went to the front of the court voluntarily got. That you have that. That's what I was asking for, the original order that got taken away from me from no fault of my own.
All right. So
I know I called
hold
CPS
on.
my order.
Hold on.
So I'm asking for that original order to be put back in place, which would be nights and weekends. You're saying a Saturday. If Christmas, so if she doesn't see fit that I can see my son on Christmas, I don't get to see him, which I didn't. I didn't get to see my son on New Year's. I didn't get to see my son on his birthday. I didn't get to see my son on Father's Day. So if she seems not fit, then I got to keep going through this game.
All right. So I stopped to ask what it was that you were looking for. I now know that. I think we need to go forward with the contested hearing. So I'm going to put Ms. Hyatt under oath. Ms. Hyatt, would you raise your right hand, please?
Yes.
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your full name for the record.
Christy Joe Hyatt.
Go ahead, Ms. Kerr.
Yes, Your Honor, thank you. Christy, at the time that your counter complaint for divorce was filed on November 23rd of 2020, had you been a resident of Jackson County for 10 days and a resident of the state of Michigan for 180 consecutive days?
Yes, ma'am.
Is it true that the allegations in your counter complaint were true at the time it was filed, and are those allegations still true today?
Yes.
Are the allegations true that there has been a breakdown of this marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that they can be repaired?
Yes.
To your knowledge,
Mr. Harsh, you need to restrain yourself.
I'm sorry.
to your knowledge, are you pregnant?
No.
Is it true that you have one child born of this marriage, namely Noah Luciana Jeffrey Hyatt, who was born March 28th, 2011?
Yes.
Have you reviewed the terms of custody and parenting time and child support as written in the default judgment of divorce? And do you believe that those terms are in the best interest of the minor child?
Yes.
Do you recall receiving a recommendation from a guardian ad litem, Mr. Kelly, on September 23rd, 2020?
Yes.
And have you followed those recommendations, including taking parenting classes, signing the child up for therapy, getting him into school, and all of the other recommendations that were specific to you as a party?
Yes. Yes, ma'am, I have. Done all of those.
Have you had an opportunity to review the proposed judgment of divorce and all of its provisions, including the waiver of spousal support?
Yes.
Are you asking Judge LaFlamme to enter a default judgment of divorce and waive your right to trial?
Yes.
Are you satisfied with the efforts of your attorney in this matter?
Yes.
Do you have any other questions for me or for the judge?
I just didn't understand what he meant when he said contesting hearing or something. What does that mean? We're going to not be divorced today?
Judge, do you have
I can
questions
answer
for my client?
I can answer that question for you, ma'am. Contested means that I'm not entering this judgment with the consent of both parties. I'm entering it at your request as a default judgment of divorce.
Okay. That's fine.
Assuming I enter it. Since Mr. Harsh apparently is contesting the parenting time provisions.
And Mr.
Okay.
Harsh,
Okay.
Your Honor,
Hold on,
Okay.
sir.
Your Honor, I would like to
Sir.
indicate that Mr. Harsh has had ample opportunity to contest this. He had an opportunity to object to the default proposed judgment. He was given a notice of hearing many weeks before this date and had the opportunity. The fact he chooses not to read paperwork that is delivered to him is by no fault the defendant's fault or my fault. I understand that he's concerned about parenting time and that if things go south again, but he's admitted, numerous times that he doesn't follow orders and that the PPO is in violation, as a matter of fact, as we speak, which I'm incredibly disturbed by, frankly. But again, these are adult people. We have gotten to this process. I have followed all the procedures and processes that the law requires. He's here at this hearing, and now he's saying I'm not okay. He's never objected to it. He had ample opportunity to. He's also claimed to have had an attorney numerous times in written paperwork that he has filed with this court on his parenting time complaints. Yet I have never received notice from any attorney. There's no appearance from an attorney, and he continues to show up in pro per.
So Ms. Kerr,
Yes,
his consent isn't necessary
correct.
for me to enter default judgment of divorce. I just was inquiring before we spent a lot of time this morning on the record, whether or not he was willing to consent to this proposed judgment. He's not.
Yes, right.
Which certainly is his right not to consent.
Absolutely.
But all right,
Could I say something, Judge LaFlamme?
hold on. I want to make sure Ms. Kerr is done.
Yes, no, yes, I agree 100%, and that's fine. I do understand. I felt like he said he wanted to make progress and move things forward, but
Okay, I do want to make progress here, and my view is that this is the sad truth, is, you know what? I can deal with Christy better, I guess, than I can with the court system. So I got to try to do the lesser of two evils here and try to do the best I can for my child. And that's what I'm going to do. I'm on the front lines here dealing with this situation. I'm not just giving lip service like Miss Kerr and saying she's very disturbed. Well, if she's so disturbed about me spending time with my son and teaching my son and doing things with him, then I guess that that's disturbing to her. Then I guess that is, but it's not disturbing to me.
All right. Well, thank you, sir. I do appreciate what you just said about working together for the good of your child. I hope both of you work very hard to make sure that your son gets the very best that either of you has to offer.
I do the best I can.
Insulate him from conflict. That doesn't do him any good. What we're ultimately concerned with here is what is best for him, and it certainly is best for him that the two of you are able to communicate effectively and work things out in a way that benefits him. So,
yes, sir.
Based upon that, I am going to grant the default judgment of divorce. I will send you copies as soon as it's entered. And I think that concludes our hearing today.
Okay, thank you. You have a nice day, and you have a nice day too, Miss Kerr.
All right, have a good day.
Bye-bye.
Thank you, Ms. Kerr.